Oral contracts are a fundamental part of our daily interactions, yet they often exist in a legal gray area. These verbal agreements, formed through spoken words rather than written documents, can be just as binding as their written counterparts. But how do they really work in the eyes of the law? At its core, an oral contract is a legally enforceable agreement made through spoken words. It contains the same basic elements as a written contract: an offer, acceptance of that offer, and consideration, which is something of value exchanged between the parties. For example, if you offer to buy your neighbor's lawnmower for $100 and they agree, you've just formed an oral contract. While oral contracts are generally legally binding, they come with significant challenges. The main issue lies in proving the existence and terms of the agreement if a dispute arises. Unlike written contracts, there is no physical document to reference. This makes enforcement particularly difficult. A famous case highlighting the enforceability of oral contracts occurred in the 1990s. Actress Kim Basinger verbally agreed to star in the film Boxing Helena, but later backed out. The producers sued and initially won $8 million in damages. Although Basinger appealed and settled for a lower amount, the case led to her bankruptcy, demonstrating the potential consequences of breaking oral agreements. The statute of frauds further complicates matters for oral contracts. This law, designed to prevent fraudulent claims, requires certain types of agreements to be in writing to be enforceable. These typically include contracts involving land sales, agreements that can't be performed within 1 year, and promises to pay someone else's debts. However, there are exceptions to the statute of frauds. If one party has partially performed their obligations or relied on the promise to their detriment, the court may still enforce the oral agreement. Proving an oral contract in court requires substantial evidence. This can include testimonies from the parties involved or witnesses, written communications that reference the agreement, evidence of performance, or circumstantial evidence showing a mutual understanding. The burden of proof lies with the plaintiff, making it crucial to gather as much supporting evidence as possible. Oral contracts also come with inherent risks and limitations. Terms can be misunderstood or remembered differently by each party. Without a written record, it's easy for disputes to arise over what was actually agreed upon. Additionally, as time passes, memories fade, making it even harder to prove the exact terms of the agreement. To protect yourself when entering into an oral contract, consider these best practices. First, try to have witnesses present when making the agreement. Second, follow up with an email or text message summarizing the key points of your discussion. This creates a written record that can be invaluable if a dispute arises later. Finally, for any significant agreements, it's always best to get it in writing. While this may seem to defeat the purpose of an oral contract, it provides much stronger legal protection. In conclusion, while oral contracts can be legally binding, they present significant challenges in terms of proof and enforcement. Understanding these challenges can help you navigate verbal agreements more safely. Remember, when in doubt, put it in writing. It's always better to have clear, documented terms than to rely solely on spoken words and memory.